Okay, so first of all, I want to welcome all of you to our webinar and thank our gracious guest, Angel Riley. Angel is a senior associate at Chevelle and Glott with a focus primarily on estate planning, trust, and probate administration. Coming from a family of real estate investors, Angel has always been interested in helping clients protect their wealth and hard-earned money. Over the years, Angel has assisted countless individuals, families, and business owners to prepare their estate plan and has appeared in courts throughout the Bay Area representing clients in complex trust administrations and probates. Recently, Angel expanded her practice to include conservatorships. So outside the practice of law, Angel has served as an adjunct business law professor for the San Mateo County Community College District. She is a member of the San Mateo County Bar Association, Peninsula Estate Planning Council, and a board of the San Mateo Chamber of Commerce and Rotary Club of San Mateo. Angel enjoys cooking, working out, exploring new foods, good whiskey, and traveling. So you can check out her profile and we'll give her contact information at the end. But I definitely want to thank you. I'm going to put all of us on mute for right now and let Angel take it away. Thank you, Angel.
Thank you, Rika. Thank you so much for that nice introduction. You know, the good whiskey part, when I put that on my bio, we have a marketing gal and she's like, you know, you may not want to. And I'm like, what are you talking about? Whiskey and cigars. That's what attorneys do. I don't do cigars, but I definitely do the whiskey part. So thank you all for being here today. I know it's lunchtime and beginning of the year, so I appreciate your time and sort of your enthusiasm to learn this very important topic, either for you or your clients or your children. So I'm going to do a PowerPoint slide for this presentation, so it's, you know, very concise and clear on your eyes. And if you've ever been to a webinar with an attorney or CPA, you know that coming up first is a very dry disclaimer. So bear with me. And then after the disclaimer, we'll get into the details. So here we are. Oh, you know what? I don't think I did the share. Okay. All right. I think we can see that. Yeah. Yep. Okay, great. All right. So, okay. So here we are, Proposition 19 and the parent-child transfer. The reason why the title of the presentation is because, as many of you may know, Proposition 19 has many aspects. I'll get into them basically in this trust or at the basic level, but the gist of this presentation will be on the parent-child transfer, and that's what the focus of this presentation will be. Okay. So, as for the disclaimer, no information presented in this presentation constitutes as legal advice, nor is it intended to be fact specific, as there may be occasions where Angel Riley or Chevelle and Glott represents clients who may be adverse to your interest. Discussion, questions, or any program content related to this webinar cannot touch upon any fact specific matters. Attendees should consult with knowledgeable legal counsel to determine how applicable laws pertain to specific facts and situations. Also, be further advised that these materials are based on the most current information available. Since it is possible laws or other circumstances may have changed since this presentation, please consult with legal counsel to discuss any action you may be considering as a result of attending this webinar. Attendance at this program and a receipt of these materials is not intended to create, nor does it establish an attorney-client relationship. Okay. So, what are we here for? So, first thing is, what is Proposition 19? How does it affect you? And what can you do now to protect your assets and children? The first question, what is Proposition 19? So, the official title of the proposition is the Home Protection for Seniors, Severely Disabled, Families, and Victims of Wildfire or Natural Disasters Act. And so it has basically three components. The first one is tax protection for seniors, the disabled, and victims of wildfire and natural disasters. Second one is the expansion of Prop 1690, which is when seniors of a certain age can carry their tax bases from county to county. Okay. And the last part, which is going to be our focus here, is revocation of Proposition 58 and Proposition 193 with limited exceptions for primary residence. So what is, though, Proposition 58 and Proposition 193? Okay, technically, they're both still effective until Proposition 19 goes into effect February 16th of this year. So Proposition 58 was passed, or effective, on November 6, 1986, and it is a constitutional amendment for California, which excluded reassessment of property tax transfers or property taxes upon transfer of real property between parents and child, or vice versa. This exclusion was applied to the original owner's personal or primary residence, regardless of the assessed or market value. This exception, Prop 58, also extended an additional $1 million limit for the original owner on transfers of non-principal residents. Okay, non-principal residents meaning investment home, Airbnb, vacation home, or second homes, commercial as well. And then Proposition 193, effective about 10 years after, is another constitutional amendment to California, which excluded reassessment of property taxes from transfers between grandparents to grandchild, so long as the parent of the receiving grandchild is deceased as the date of the transfer. Both of these propositions will expire on February 16th, 2021. Okay. So what is then Proposition 19, and how does it affect you after February of this year? So first of all, Proposition 19 completely eliminates the lifetime $1 million non-primary residence exclusion. And I'll give examples of how these play out in the next couple slides. So first of all, eliminates any non-primary residence exclusion from reassessment of property taxes. Second of all, it eliminates the primary residence exclusion unless the child resides in the primary residence received from a parent. And even if the child resides in the primary residence or the inherited property, the child's assessed value is then determined based on the property market value at the time of transfer. In other words, if the value of the property at the time of transfer exceeds the parent's assessed value, okay, by less than $1 million, okay, less than $1 million, then the child takes the parent's assessed value. There is no reassessment. However, if the value of the property at the time of transfer exceeds the parent's assessed value by $1 million or more, then the child's assessed value is the current value of the property less $1 million. Okay, that was a mouthful. So what does that mean? Okay, let's say you have Mother A. Okay, she's got a primary residence in San Mateo that has a market value of $950,000. Okay, the assessed value on her annual taxes is $100,000. And so she's sitting on a very comfortable annual property tax rate of about $1,290 a year. Under Prop 58, which again expires February of this year, Mother A can transfer this residence to her child, and the child will be completely excluded from reassessment, and the child does not have to move in. Under Prop 58 also, even if Mother A turns this primary residence into an investment home, a rental property, under Prop 58, she can still transfer this property to her child, and that child would not be reassessed because the annual or the assessed value is less than $1 million. That's Prop 58. Okay. Under Prop 19, When Mother A transfers this property to her child, the child must reside in the property. Okay, she must declare that as her personal residence or primary residence with the county. And in this scenario, the child would be excluded from reassessment. And the reason why is because the market value of the property does not exceed the parent's assessed value plus $1 million. However, if let's say the child receives this property and he or she does not want to live in it, well, too bad. This property is going to face full reassessment of property taxes. Okay. Example 2. Mother B has personal residence that has market value, fair market value of $3.5 million. And let's say the assessed value for said property is $500,000. And so she's still sitting on a pretty comfortable tax base of about $6,000 a year. Again, under Prop 58, Mother B can transfer this property to her child and then it will be completely excluded from reassessment. The child does not have to move in. Even if Mother B turns his residence into an investment home. Okay, still under Prop 58, Mother B can transfer this property to her child, and the property taxes would still continue to be at $6,450 a year, with, of course, the annual adjustments, because the subject property has an assessed value of under $1 million. Come after February 16th of this year, under Prop 19, there's going to be 2 scenarios. Scenario 1, the child moves in to this particular inherited property. And if that's the case, then the child is going to receive a partial reassessment. And what you do is you take, the current assessed value, which is $500,000, and you add the fair market value of $3.5 million. And then you subtract the assessed value plus the $1 million exemption, which basically lowers the assessed value or the market, sort of the assessable value, to $2.5 million. And you multiply that by, the general 1.29% property tax interest rate, and still, or the result would be an annual tax rate of about $32,000. So quite a large increase.
So Angel, a question came in about, is there a time frame the child needs to move in by?
Yeah, so I received this question last time I held one of these webinars, and I searched what was available to me through California on Prop 19 and this one particular question. I couldn't find it, but my gut instinct tells me that you probably have a short window, and I would say under 6 months. The reason why is, let's say the transfer happens May 1 of 2021. The moment you submit that deed, okay, that's the date of record, that's the date of transfer. The county or the assessor's office, they're not going to wait to process that partial reassessment or full reassessment, right? And so usually what I see, and just in the last few years, upon receipt of any deed, if there is a reassessment, the new owner is going to receive kind of like a warning letter. This is what we see, and this is how we're computing your new taxes. That letter usually comes out 3 to 4 months after the date of transfer, depending on how backed up the county is. If you don't timely respond to that, meaning you don't declare this to be your primary residence, the next bill you're going to get is usually a supplemental tax bill with a due date to pay that bill. And then the bill after that is going to be your regular annual tax bill. So I would not wait to claim something or some property as your primary residence if you're looking to receive an exclusion or sort of an exclusion for full reassessment. Okay.
So another question, Angel, on top of that, can you move in and then move out and not be reassessed?
That was another question that I received. So sort of off the record, I suppose you can, because here's the thing, right? Once you move in, you claim something as your primary residence and you move out, you're not going to notify the county, hey, I've moved out, please reassess me. And also the county does not go door to door checking if somebody is actually living in a home, right? With that said, you're kind of taking that risk because my gut instinct with this proposition is that you are required to live in this home indefinitely if you want this tax basis. But then again, off the record is if you did move out, how would the county know, right? Just as a caveat, or sort of a follow-up to these two particular questions, a lot of the information that I have here is information that, over the years, I've collected in terms of my tools, so to speak, of effectuating transfers between parents and child, and also what's available to really anybody in public currently online regarding Proposition 19 from the state of California. Usually when a proposition, or always when a proposition passes, we don't know, meaning you, the assessor, me, you, the assessor's office, we don't actually know how it's going to be administered until the people up in Sacramento meet to then codify this proposition into administrative terms. And so that's why when I say, I look, but I couldn't find it, I'm going off my gut instinct, that's why, because we know sort of the basic platform for which Proposition 19 stands on, but in terms of administration, how each county is going to administer Prop 19, we won't know that. We won't know that until probably late this month or early January, because the basic handbook to how to administer this has yet been published. Okay. All right, so let me move on to this second outcome. Okay, so the first outcome is if the child moves into this subject property. The second outcome is if the child does not move into the property and the child makes it his or her investment property, well, you're going to face full reassessment. Okay, so 3.5 million times the annual tax rate or the tax rate at the time, and you're looking at right now about $45,000 a year in taxes. Okay. This would also be the case if in this scenario, Mother B did not transfer primary, but instead transferred investment property. So what can
Sorry, Angel, to interrupt, we have some more questions coming in. Do you want us to wait until the end? Because I think you'll probably answer some of these.
Yeah, you know what? Let's wait till the end, and then I can, yeah, okay. Perfect. So what can you do now to protect your assets and your children? Okay, so pretty much there's 4 options that I have. And there are options that, most of them I pull from my usual toolbox that I've used over the years to effectuate parent-child transfers, because Prop 19 does not change the definition of parent-child transfers. It just excludes certain exceptions or exemptions. So option 1 is prior to February 16th of 2021, you can give the property in its entirety to your child or children. Option 2, you can transfer the real property to your child or children so that the owners of the property become original transferors, or another way is joint tenancy. And the third way is you can transfer a 51% interest to a child and hold the asset with the child in an LLC. Okay, joint tenancy and the LLC option, in my definition, I call them sort of the quirky rules of property tax reassessment in California, because depending on how title is held between joint tenants, if they are considered, if you transfer the property properly, then they will become original transferors, and upon the death of any joint tenant, the property transferring to the surviving joint tenants, in other words, the original transferors, is not subject to reassessment, but that's only if the transfer is done correctly. And as far as the LLC option, that's just based on the rule of not transferring more than 50% interest in an LLC, a cumulative more than 50% interest in an LLC, or changing control in an LLC to then trigger reassessment, which is why the outset of the transfer is 51%. A little bit more complex, but it works. And the last option is an irrevocable trust with a general power of appointment. okay, retained for the parent. This works as well, okay, but this, it's a new tool for the purposes of Prop 19, and it's something that's been discussed pretty often or consistently with practitioners in this area as a tool to mitigate Prop 19 for kids. Okay, so what are my recommendations to you before you make any transfer? First of all, talk to your children. I've had numerous calls with clients in the past, I would say 2 months since Prop 19 went into effect. And about half of them became sort of non-issues, because after the parents talked to the child, the parents realized, often for the first time, when I pass away, my child really doesn't want my house. They don't really want to be a landlord. They'd rather, sell the property and take the net proceeds and do what they want to do with it and live their lives. If that's the case, really, there's no need for you to do anything with Prop 19. If that's not the case, and you have children that want to live in your property until they pass away, or that they want to invest in your investment property, and sort of carry on that tradition, you want to, of course, consult with an attorney and your CPA, because all these options that I address, there are responsibilities as it relates to gift tax returns, and there are consequences as it relates to step up in basis and capital gains. These are very important things that you have to understand, and really your children as well, so that the transfer is not something that can trigger something unfavorable years down the end. Okay. And whatever you do, you want to do so now. Prop 19 is effective February 16th of this year. We don't have a lot of time. My cutoff date pretty much for all my clients is at the end of the month. If you're calling me the first week of February, I will more likely turn you away because it's too close. Okay, and February 15th, I believe, is a holiday. So really, it's February 12th that you have to effectuate these transfers. Okay, so with that said, I have the disclaimer up again, and I know Rika has questions for me. And what I'm presenting here is meant to be really a crash course on Prop 58 and Prop 19, but I wanted to leave room for you to really digest this information because it is a lot, and then ask me any of your questions. Yeah, so I guess at this point, Rika, the floor is yours.
Okay, we had a couple of questions come in through the chat, some comments and some questions. Okay. So a comment was said that the assessor's office does realize when you are not using a residence as a primary residence. And then a question came after that, is that true of any property changing from primary residence to income property?
Is that true? Is what
so
true?
Yeah, Marcia, if you want to.
It was in response to the conversation about how long do you have to reside in a property to maintain the discount of the assessed value. So if a child moves in, lives there for 5 years and moves out, you talked about they won't change it unless they are made aware of it. And I was just sort of wondering, if we moved out of our house now and turned it into an income property, are we potentially liable for it being reassessed because now it's income instead of our primary residence? And I was just,
so
the rules should be the same.
Yeah, so it's not for current owners. So if Marcia, you and your spouse decide to move somewhere else to make that property primary and this property investment, your taxes will not go up. This is really affecting transfers from current owner, either as gift or by default of debt.
I just wanted to make a comment about the assessor's office not knowing whether or not you moved. So when I had a house in Huntington Beach, and that was my primary residence, and then I moved here to Foster City, and this is now my primary residence. And so at least down in Orange County, you get a $7,000 break or whatever in property tax if that's your primary residence. And so they actually did track me down last year and basically say, because of you started your primary residence in Foster City in 2018, so therefore you don't get this discount anymore. So the assessor's office is able to keep track of whether or not this is your primary residence or not.
Well, yeah. I mean, what I said earlier, again, it's sort of your judgment call of whether or not you want to take that risk. I personally would not, because, you know, as Diana said, that's definitely something that could happen. My guess is, Diana, when you purchased your here, you probably filled out the homeowner's exemption form, where you check that box. And then, so if you check the box, it's in the system in California. And so, you know, counties then sometimes then will talk to each other and say, wait a minute, you can't have, you know, so what I was saying earlier is, if, you know, again, you wanted to take the risk and you wanted to, you know, let's say move to, you know, a smaller condo, but have your Hillsborough house as your primary residence, but then you don't claim the homeowner's exemption on the condo, then really the county would never know, right? But then again, your judgment call.
So Jeff and Marcia, do you want to, they had a question about the lifetime limit to how much you can gift to someone. Is there a limit?
So, well, the current lifetime limit is still $1 million for non-primary residents between parent and child. So it's parent and child, right? Or grandparent and grandchild, assuming the child in question to the grandchild is deceased. And so that 1 million, it's not going to apply to a brother. It's not going to apply to an aunt. It's not going to apply to a friend. Once Prop 19 goes into effect, that $1 million exemption off the assessed value for non-primary will no longer exist, right? And so what will take its place will be the $1 million sort of discount if the child receiving the property, the primary residence, moves in. And again, the property in question had to have been the parent's primary to the child's now new primary. Okay, so that's the rules have become much more strict under Prop 19.
Okay, Marcia.
So really my question was, like, one of the ways that you listed that you could like get around the Proposition 19 was to gift, I think was to do a gift or something.
Yeah, prior to the 19th,
yeah.
or the 16th.
But if your home is worth more than $1 million, can you gift the home to the child? Because if there's $1 million limit.
So there's two different ways that gift can transfer, right? So, or in terms of taxes. So if the property is a primary residence, as of now, before February of next year, you can gift that property to a child, and it doesn't matter the market value or the assessed value. It does not matter. If this property is a investment property, you have $1 million exclusion off the assessed value. It is not market value, assessed value. So if the parent's assessed value is 200 grand and the property is worth, you know, 3 million, you're looking at only at the assessed value of 200 grand, which would fall within that $1 million exemption.
And this is only before February 16.
Correct.
Okay.
I don't think we're giving that house.
I don't think so.
Okay, I'm going to go down. We did get a list of questions that came in prior to the webinar, and you may have, I think you've answered all of them. So if this is your question, audience, and you need more clarification, please let us know. But a lot of it had to do with if your property is held in a trust, does Prop 19 still apply? And Angel did talk about that. And I think the biggest aha, because the people, for me, for what Angel said, is if you're planning to, if you inherit a home and you never had any plans to live in it in the first place, it really doesn't apply to you because you're planning to sell it anyway. Am I right about that, Angel?
Yes, the second part, and the first part, just to maybe a touch up on it again, is no, even if a property is in a trust, it's not going to shelter you against Prop 19. If it's in an irrevocable trust, depending on the beneficiary, that may change, you know, the case. But if it's in a revocable trust, you know, if you do nothing and you pass away, let's say, you know, I don't know, May of 2050, and Prop 19 is still the law, your children can face reassessment.
That's interesting that you said that if Prop 19 is still the law, because obviously another proposition can come between now and whatever and change everything
could.
again.
It could, yeah. And I've been getting questions of, do you think someone's going to contest this Proposition 19? Do you think it'll go to the state? And, you can't blame the ballot, because if you remember looking at the ballot at the bottom, it specifically told you that basically don't depend on the descriptions on the ballot, and essentially telling you to do your own research. So you can't blame the ballot, although in my opinion, I think it was misleading, but still, you were informed that it's not the description there, or that there's more to the description. As far as any, I guess, legal contest to Proposition 19, the first thing that I can think of is the Fifth Amendment of the Constitution, the U.S. Constitution, which is it's called the takings clause, which basically means the government can't take your property without just compensation. That's been something that's been floating around with attorneys and with my clients of, arguing this sort of legal clause to overturning Proposition 19. And yeah, it's possible, but the reality is it's not a taking, in my opinion, per se, because you can sell it. You can sell it and get market value, and that's compensation. That's just compensation for you. And the fact that the children can't afford the expensive taxes, I don't think, in my opinion, amounts to a taking. So, I mean, it's just, these propositions are passed, and we do what we can, like right now, to work around it and try to protect your assets.
Okay. Does anybody have any specific questions? Because a lot of these are kind of asking the same thing. How will this affect my children? I believe Angel's talked about that. Please clearly explain the changes and what we can do to protect inheritance so we're not taxed to death. If there's anything specific beyond that question, whoever asked it, please let us know. I'm just going to read through them because I believe Angel's covered a majority of this already. Marcia, I see that you're unmuted. Do you have a question?
Not, it's not a question that was listed before.
Oh, okay. Do you want to go ahead and ask?
Was Prop 19 like allow a senior to move multiple times and take their tax
Their property tax basis? Yeah.
Yeah, so Proposition 19 did expand Prop 60 and 90. In this particular, I'm not well versed in that particular area of Prop 19, just because my focus has been sort of the emergent aspect, and this is the emergent aspect because we have a February deadline coming up. But that particular aspect of Proposition 19, I believe, is not effective until April of this year. I don't have more information on it. What I can tell you is that it did expand Prop 60 and 90 to all counties in California, which is favorable for seniors.
So to piggyback on that, we're going to have an enrolled agent and CPA talk about that specifically in a couple of weeks. So look out for our next webinar from Meraki Real Estate, that we're having someone speak about that point of it in Proposition 19. Because as we started off in the conversation, there's many nuances to this proposition besides what Angel's shared with us today. So, oops, somebody got bumped out of the way. Okay, so primary resident. Hello. Sorry.
Hello. Can I ask a quick question here?
Oh, sure.
You said that your joint tenancy was done correctly. How do I know I have my home as of now in joint tenancy with my daughter? And I want to know, how do I find out if it is done correctly or not?
Okay, so I think the question is, how do I know if the title to my property with my daughter was done correctly to follow the joint tenancy?
Correct.
Is that correct, Robin? We're having a little bit of hard time hearing you.
Yes, that is correct.
Okay.
I put my home going to my daughter last year, or actually
Okay,
and
so
I
so
just,
so the yeah, so the easy answer to that question is look back on the deed, and if you don't have access to the deeds, I can get them for you fairly easily. Um,
I have the deed.
yeah,
I
so
do have my deed.
okay, yeah, so look back on your deeds, and if you need help understanding, if it's done correctly, I recommend Robin, give me a call or shoot me an email after this call. And essentially, all we need to do is look back on your deeds to see if it was done correctly.
Okay, great. Thank you.
Thank you, Angel. So I'm just going to read through the rest of the questions, and then if anybody wants to jump in, please let us know. We talked about primary residence as well as rental properties and family trusts. If there's anything else you guys want to add on that. Yeah, my big question is, if the house is in a trust, how does this affect inheritance taxes, which again, we covered. Are properties transferred prior to 2021 excluded from the new tax laws? And
Yeah, so let me brush up a little bit on the inheritance inheritance tax question. So my assumption of what this writer means by inheritance tax is federal estate taxes. Proposition 19 has nothing to do with your estate taxes. That's a whole different area of the law. Again, if property is in a trust, you're not excluded from Prop 19. Okay, so inheritance tax is separate, in my definition, separate from property taxes. And then to the second question, I'm sorry, Rika, can you remind me what that last question was?
absolutely. It says, are properties transferred prior to 2021 excluded from the new tax laws?
From what I know so far, no. And I've spoken to assessors about this, questioning them to see, have you heard anything from the pipeline? What do you think? What's your gut instinct? And consistently, they've said pretty much, I hope not, because it's a lot of work for them. And also, it's a little unfair. So I don't think that California will do this. Although, like I said, the actual administrative pamphlet of what Proposition 19 looks like in practice, nobody has that yet. Nobody.
Okay, thank you. I'm going to read this whole thing in its entirety. It says, my understanding is when the transfer of ownership is effective, the property tax is calculated based on the current market value of the price of the home. Is the bottom line, if you want to have the same low property tax for the kids, you will need to have the title or deed transferred and recorded to the kids before February 16th. What if my parents' property is currently a rental? Does anything change?
Nothing changes.
Hold on a second. I don't know why it muted.
Yeah, you went on to mute.
There we go. Okay.
Sorry about that. I was trying to mute myself and I muted you.
No worries. Nothing changes in terms of sort of the applicability of Prop 19 to this particular writer. So rental or residential, trust, it doesn't matter. You are not privy to anything different than Prop 19. As far as, the question of how do I maintain my tax basis for my kids, you have to make the transfer. You have to make it now, or you risk them getting reassessed after February of this year.
Okay, thank you. And Ramona has her hand up. So Ramona, you can go ahead and unmute.
Hi, thank you. So expanding, can you hear me?
Yes.
Okay, great. Could you please expand on, I think it was the last point of, if it's in a trust, changing it to an irrevocable trust. What are the benefits of doing that?
Yeah, sure. So this is something that really is kind of a new phenomenon for me, and new because Proposition 19 was passed in November. And what I've gathered from other practitioners that I've spoken with to brainstorm ways to help our clients is, in California, when anybody creates an irrevocable trust and puts property in that trust, California sees that as a transfer or as a change in ownership. And so if you create this trust before February of this year and you put your property in this trust, you can utilize the parent-child exclusion because California will see that as a change in ownership. On the federal side, okay, which is the IRS, if you retain or if the parent retains the general power of appointment, the IRS still sees that property as part of the parent's estate. Okay, so when the parents die, they can include that in their estate tax return, thereby getting the benefit of the step up in basis. Okay, so that's why clients may want to utilize the irrevocable trust route. Yeah, that's how that avenue works.
Okay, thank you. I just want to make sure I'm understanding that. So in general terms, if you were to make the trust irrevocable, it's almost like freezing it in time. So everything that applies when it was frozen as an irrevocable trust will be still effective when the family inherits it. That, you know, same on behalf of my dad, I'm trying to help him out.
Sure.
So actually his trust is half frozen already because I have lost my mom. So part A is already irrevocable, but he's still alive. So 50% is revocable, which he's in charge of. So he just wants me to protect what he has set up. So if I'm hearing you, if he were to make his 50% irrevocable, would that from here on with his investment properties, would they still have those tax benefits until he passes away? And then we'll deal with
so Prop 19 really doesn't affect him, right? So he's going to be fine in terms of, you know, because it's not going to create any kind of reassessment for him. It's really on the back end when property is transferred to you and or you and your siblings. As it relates to your question, irrevocable trust is not something that I frequently draft, to be frank. And so, you know, and even those that I've read or seen, I rarely see, you know, a portion in, you know, what you're talking about, 50% in sort of this bypass or marital trust and 50% in this irrevocable trust for the purposes of Prop 19, because then you have two different irrevocable trusts. And at some point, the property, at least 50% of it, can be reassessable because this first bypass or marital trust that was created when your mother passed away, that I assume when your father passes will naturally flow to you and or your siblings. That's still a reassessable event. So yeah, I'm not quite sure how that would be set up. If you want to give me a call after this webinar, maybe we can discuss it some more.
Thank you.
Sure.
Okay. The last question is going to be for the next webinar because it says how they figured out how they will phase out Proposition 90 and implement Proposition 19. So folks, be on the lookout for our next webinar and we'll have a CPA talk about that portion of Prop 19. Does anybody have any other questions for Angel? You can take yourself off mute if you do have questions.
The last webinar that I did, somebody in the call was like, I'm traumatized. I have no questions.
I hopefully nobody here is traumatized. But I did ask Angel to leave her contact information. Hopefully everyone can see it there on the screen. And if you don't have it, you can certainly reach out to me and happy to pass that along. Angel, it's been a pleasure. I was looking forward to this myself and so many questions around this proposition. So thank you so much for your time and your knowledge and expertise. Well, it looks like somebody's trying to enter the waiting room right now, but we're just about to end. Is there anything you want to add before we end the webinar, Angel?
Yeah, first of all, thank you, Rika, so much for having me here. It's a great opportunity, and thank you for inviting me. I geek out with this kind of stuff. You know, it's it's just what I do. I enjoy helping clients sort of protect their assets and protect their future generations. So it's always fun for me. And you gave me a chance to see if my suit jacket still fits and put my face on. So it's been a fun day. For anyone in this group that's interested in speaking with me some more, you're welcome to call me, shoot me an email, and we'll do our best to help you. And again, my name is Angel, and it's been a pleasure.
Thank you, Angel.
Thank you so much.
Thank you, everybody. It's great to see you all. And we really appreciate
Thanks.
it, Angel. Thank you. Bye, everybody. Happy
Bye-bye.
New